So we are live, and it's a very, very warm welcome to you all from the University of Dundee and Dundee Law School. And really, we're coming to the final phase of this year's competition. We've been enjoying some fantastic internal competitions over the last few weeks. I know that our judges have been incredibly impressed with the level of mooting. So it promises to be a really, really good competition coming up in March. Now, I know that we'll be covering a few things as we go through the slides, but just a quick reminder of how these sessions will work. So our student tutors today will be taking you through constructing your argument as counsel for the appellant, and that will be for the international problem, which we sent on to you all last week. Top score really for those schools that noticed that the problem might be a little bit familiar, and just really to reassure you that this is something that's quite common. We do often recycle problems. There are only so many problems that you can come up with at the right level, and we felt that I don't want to say too much, but we felt that with so many new schools joining us this year, it was good to have a little bit of continuity between the internal and the international competition. So there is a Q&A, and that is, there's a double bubble down at the bottom of your screen. So if you have any questions, you can either put them in the Q&A there, or do feel free to, you can raise a hand, and I will be able to see that on my computer, and I'll be able to unmute you, and you will be able to speak if you feel comfortable doing that. But it is good to remember that this session is recorded, and the recording will go to all of the schools. So I think without further ado, was there anything else, Kelsey?
I don't think so.
And I should say apologies from Professor Peter as well. So Professor Peter's not able to join us today, but I think hopefully he'll be back next week. And he has been also enjoying some of the internal competitions as well. And again, talks of a very high standard across the board. So but I think without further ado, we will move on to our session today, which is all about constructing your argument as counsel for the appellant. Over to you guys.
So firstly, we'll just start with kind of the recap of the rules, which are kind of the same rules that we had for the internals. So without further ado, I'll just kind of go through what's going to happen in the international competition for those who maybe couldn't join us for the internals. So hopefully you've got the dates right. The competition will run between the 11th to the 18th of March. So I'm sure Libby will be contacting schools and trying to, set a few rounds for the competitions. So the system that we have usually used is that each team from a school will moot twice. So you will have the opportunity to present a case and act for the appellant, and then you'll be able to act for the respondent. So therefore, you need to prepare for both sides for the international competition, and the order will be junior appellant, followed by the junior respondent, then the senior appellant and the senior respondent. So it's the same order as the internals competition. So just a brief reminder. So when we've kind of given you the international moot problem, we've also given you the judgment pack. And as judges, we don't want you to kind of stress about looking for your own cases. So for your convenience, we've compiled everything that you will need within the judgment pack in order to come up with submissions. And the time limit is 7 minutes, and this includes judicial intervention. So Libby has been our clerk, so you're quite familiar with her holding the signs up. So, 2 minutes for 2 minutes remaining, 1 minute, and she will also have kind of a sign for, call time. So that's kind of when you're meant to be done and you've used your 7 minutes. So each moot will be scored out of 100. And the criteria is oral presentation, your legal argument, how well developed it is, your response to questioning. So essentially during the judicial intervention, whether you've answered our question and kind of how you respond to the questions we have, your courtroom manner and etiquette, your teamwork. So junior and senior, we like to see that you have a cohesive argument and that, essentially you've worked together, and we can see that during your submission, and kind of the overall presentation. So how your tone, your volume, whether it's clear, are you speaking too quickly? So we take all of these factors into consideration. And some of you may be familiar with this because we have given some schools the marking kind of scheme or the paper that we often use. And finally, it's very important that you do not need to prepare a skeleton argument or bundle, even though we mentioned that in some of our first kind of beginning lectures. You can just direct us to the cases in the judgment pack. So I think we've kind of got 2 slides, but I'll just run, through them very quickly, just general feedback so that we can kind of reflect on what we think we did well and hopefully kind of come into the international competition with our best kind of shot at it. So firstly, we really appreciate and liked the eye contact. I think we gave some schools really good marks for that because it really is important for us to kind of engage. Unfortunately, we can't do face-to-face competition, so this eye contact is extremely important to kind of replicate how it would be like in real life. Secondly, I think there were a few kind of confusions or misunderstandings about the terms ladyship, my lady, your ladyship. So we clarified that each and every time, but we thought we'd just clarify it again to everyone. So for an all-female judging panel, so luckily, it's quite easy. So if you see that, oh, okay, I've got Kelsey and Hannah as my judge, if it's just the 4 of us, you can kind of expect to call us your ladyship or my lady. But then if Professor Peter kind of comes into the mix, it becomes a little bit, complex. So then you'd have to refer to us as your lordship or my lord, because that's generally how you would address a panel when it's mixed gender. So that's kind of an important thing to get out of the way. So as soon as you see Professor Peter, you can immediately change it. And some of the tips that, we've given is when you're writing your script or preparing it, just write my L or your L so that you can kind of suit it to whoever is judging it on the day. And additionally, we've got, you can also, if you're so confused, you can instead refer to us as the court. So if I could direct the court to page 7 of the judgment pact. And we've also had some cases where schools have kind of relied on authorities outside of the judgment pact. And for us personally, so that we can check and fully engage with your submission, we prefer for you to use only the cases in the judgment pact. And with that comes in mind, when you're mentioning the case, it's really nice when you actually give us the page number of the judgment pack so we can scroll and look at the judgment and properly follow your submission. So another thing, so tip number 5 is kind of make full use of the time, because really this is your opportunity to show off to us all of the hard work that you've put in. Because when we are in kind of the workshops, I'm always so happy and so impressed with kind of how well developed and the kind of arguments that you're coming up with, and we'd love to see that in the competition. So for us personally, we would say 5 minutes. So 5 minutes is a good kind of benchmark of how developed your submission is. So if you're able to speak for 5 minutes, for us, that's, an indication that you fully, cited it and your argument is clear and concise, but you should also leave some time for judicial questioning. So 5 minutes is, the basic rule, and leave just 2 minutes in case we do ask you questions, because it is incorporated into the full time. And finally, we really do appreciate having a conclusion at the end, which kind of summarizes what you've been arguing for 7 minutes, because sometimes it is difficult to, remember and be on track. So I think we've given a tip for, most schools was, I think a conclusion is, if my lady has no further questions, I would like to proceed to conclude my submission. And that is, firstly, the appellant does not meet the first ground because, so you kind of repeat what you've argued in a summarized version. And then at the end, kind of have a one-liner where it's like, if it pleases the court, we would therefore invite the court to allow the appeal or dismiss the appeal, so that we really know at the end of the day what you want us to do with all of this information. And tip number 7 is kind of the junior appellant, so the first speaker, it's kind of their job to offer the facts of the case to the judges. So once the junior appellant has done that, and the judges have said, it's okay, well, we are well acquainted with the facts of the case, then kind of the people following that don't have to ask us again whether we want to know the facts of the current case, because the junior appellant has done that in their role. And if we do want the facts of the case. So if you ask us, oh, would my lady like a brief summary of the facts of this authority? And we say yes, but very briefly. Ideally, all of your kind of facts should be 4 to 5 bullet points, really. So really brief, don't go on for too long. And finally, V in the cases or in the case names should be read as and. So for civil cases. So we kind of explain that there's a difference, but for the international moot competition, it's definitely a civil case. So just pronounce all of the cases as and.
So I think the next few slides I'll be talking to you about, but I think we saw a question in the Q&A. I don't know whether
Yes. Do you want me to
anyone
voice it
else
to
was
you?
trying to answer that. But it was I'll just read it out for the purpose of the recording. It says, is it better to tell the judge that we'll be using the full judgment before the moot? So in terms of the materials you'll be using during the moot, that'll all be in the judgment pack for you. And in the judgment pack, it's laid out with facts of case, the name of the case at the top, facts of cases, and then some quotes, which would be helpful for you to use during your moot. So what you'd be quoting from would just be the ones there on the pages of the judgment pack, and you can use that to kind of support the legal submissions that you're using. I don't know if that helped clarify things, but if you have another question branching off of that, please do let us know and I can answer again for you. So to speak a bit about the role of the appellants, the junior appellant has a few things that they need to do admin-wise at the start of a moot. So they need to introduce the judge to the members of the court. So that would be introducing yourself and your partner, and then also the names of the respondents as well. So once if you're unsure about any of those, once you join the call for the international competition, what we did for the internal one was we asked people to just change their name on Zoom to their first name and then either junior respondent or senior respondent or senior appellant. And that way you can just quickly edit that in your speech. So you have that for when you're doing your speech. And then you'll also introduce the 2 grounds that you and your partner will be arguing. And you'd say, I'll be taking the first ground and my attorney will be taking the second ground. You then want to offer the facts of the current case to the judge as well. And the moot problem is quite extensive in terms of the facts. So it's up to you which facts that you want to pick out as the most important ones and summarize that into a few bullet points. And then you can give that to the judge just so it doesn't eat too much into your time. And then just as a final point as well, in terms of offering facts of the case to the judge, once the junior appellant has done that, that's done for the moot. So nobody else needs to offer facts of the case of the moot problem to the judge after that. So these are the facts of the case for the international competition here. So depending on what you deem important, you're able to summarize those into the best way to present those to the judge. I'd probably say quite important is usually dates, a good thing to be aware of, and then specifically in the problem, just like something stating what the problem's about. So things like terms like letter of acceptance, when they passed the letter, what date it was, and then when they denied liability, that would be important as well, what they charged them for, and then what the previous court found and who they ruled for. That will kind of help outline it for your judge. And then once you've done that, you can kind of say, and we'll be arguing again for the appeal or against the appeal, just depending on what side you're on. So the grounds of appeal for this specific problem, they're split into 2. So as your team, one of you will be taking each of them. Usually it'd be the junior takes the first ground and the senior takes the second ground. So as junior appellant, you'd be taking the ground that Mr. Justice Mansell erred in ruling that Aaron was acting within the course of his employment. Instead, Aaron was engaging in a frolic of his own, and so Hot Wheels Garages Limited was not liable for damages to Mr. Von Speed's supercar. And then the second ground of appeal, which would be taken by your senior, would be Mr. Justice Mansell also erred in ruling that the postal rule applied. So this one's kind of like an additional ground. So additionally to the first ground that your junior would be presenting, you're presenting this one. And you'd say the advert clearly stated that the acceptance to the offer must be sent through Royal Mail, so Von Speed was not entitled to pay only half the price of the original repairs. And then we're going to go into a bit more detail just on both of the grounds now and speak about them a little bit more so you have some more context on those. Firstly, a quick note on how you'll be preparing for the moot as a pair. So you can work separately on your two grounds of appeal, but both of you should try and have a general understanding of both of the grounds. For some cases, it's easier for you to have the junior handling the first ground and then the senior handling the second ground. But it's always best to have both. Just in terms of if the judge might ask you a question, you could say, my senior will be covering this aspect of the argument, or even if it gives you a more broad understanding of the case as well. Try your best to fit in as many cases as you can within the time limit, but balance that out with legal argument as well. So I'd probably say if this was to be, you'd spend 5 minutes, I'd probably say using 2 cases, 3 maybe at a push, but definitely 2 just so you can expand on legal argument. And that way your submissions are well developed, and the teams will vary from school to school. So you could have 4 members in your team or 2. So while you're doing your research, make sure to utilize every member of your team for legal research.
Thanks, Ria. I'm just going to jump in quickly and answer some of the questions we've got. So there was a bit of clarification on the question that got answered earlier that says, I mean, if we were using the detailed cases, so i.e. the actual case judgment, the PDFs that we also provide you with, like if we found better quotes in the same case but not in the judgment pack, how do you direct the court to that? I would just say that it would be best to state when you're introducing the quote that you'll be referring to a quote on page 3, on page 5 of the full judgment. And we can quickly look to that because we just want to make sure that you're not relying on a quote that wasn't actually the judge. I'm not saying that that could happen, but it has happened to mooters at the university before, and it's really important because the submissions of counsel are not law, and to be honest, we don't really care about what they say. So it's just important that you use judgment quotes, which is what we've included in the judgment pack. But do try to stick to the judgment pack where necessary. And there's another question about what about when you're referring to a case that the junior appellants didn't use? Do you still ask the judge if they would like to know the facts of the appeal? Yes. So if you're introducing a new case to the judge, for example, one in the judgment pack, it is beneficial for you to ask them if they would like a brief summary of that case. And then if they say yes, then you would give them a brief summary. But we do know a lot of the judgments that are in there, and we will tend to say no. So it's not that important, but it is important for the first junior appellants to make sure that they ask the judge if they want the facts of the current case, i.e. the moot problem. And
it may be as well that you're
sorry.
relying on, it may be that you're relying on a case where the facts aren't necessarily relevant to your argument as well. So it could be that you say something to the judge, such as if the court is happy to proceed without the facts of the case being presented due to their relevance, that way you can proceed on with the submission. But that's just if you were relying on a point of law, like you were going to use a quote, but it wasn't specific to the facts of the case that you're using.
Yeah, perfect. And we have another question about, can you refer to your senior as co-counsel? I would say no, just because there are a reason we call them senior and juniors, and it comes to the bar. So usually the senior counsel, I don't want to say is the more important one, but they will usually take the lead on things. So I would just call them your learned senior. It's just easier. Okay, sorry, moving on.
Hi everyone. So I'll just quickly cover the first legal issue of the problem question. So I'm not sure if you've all kind of read the problem question in detail, but as been summarized, basically the question is whether the employer is liable for the actions of their employee. So this is what is called vicarious liability in English law. It says it is a secondary type of liability. So what is meant by secondary is, for example, if I commit some wrong, I don't know, I punch someone. It is, so it's my liability. I am the primary liable person. If I am employed and I'm doing that in the course of my employment, my employer is also liable, but it is a secondary type of liability for him because he did not punch anyone, I did. So that's kind of the idea behind it. Basically, vicarious liability is when someone superior, employer usually, is liable for actions of their employee. Usually that's very relevant in terms of compensation, because in tort actions, what is happening is that people seek monetary compensation. It's usually much more beneficial to go after someone that actually has the finances. And that's usually the business, the employer, basically. So because it is such an important topic, there are 3 requirements that have to be fulfilled. So the first one is that there must be an employer-employee relationship. So you're basically employed. The second one is that you have committed a tort. And as I said, the tort is just something like a wrongdoing. As it says, it can be a negligent act, but it can also include some intentional acts such as theft. And the third requirement is that the tort must be committed while the employee is acting in the course of their employment. So this is a very important one, that your employer will be liable only when you're doing something relevant to your job. So if you're a waiter and you go on do some completely irrelevant thing, that is just not going to fall within the scope of vicarious liability. So yeah, as it is mentioned on this slide here, at first instance, the court found that the Hot Wheels were vicariously liable, meaning that the boss was liable for their employee. As an appellant, you will be arguing that the Hot Wheels are not liable. So to argue that they're not liable, you will go back to those 3 requirements and you'll argue that those requirements are not fulfilled. As I mentioned, the main requirement there is that, not the main one, but very important one, is that you're acting in the course of your employment. So it is, I think, a very good tip that you should spend most of your time speaking about the fact that Aaron was not acting in the course of his employment. And I think if we could go to the next slide, the term for this is the frolic of his own. So you will be arguing that Aaron, while he was committing the actions he was committing, was acting on the frolic of his own. What that means is basically that he was acting completely out of his employment. He was doing something completely irrelevant to his job as independent journey. You can mention his motivations. That is a good point to make, whether on the point of whether it was in the course of employment. So was he doing that to fulfill his role? So was he racing that car because it was relevant to the job? Was that very necessary? Or did he do that just because he thought it was fun? So if it is the latter, it is very obvious that that was just his independent idea and not in a way related to his job. The employer may also avoid vicarious liability if the action of an employee was prohibited, but at the same time, this argument can be kind of avoided. So vicarious liability can still arise even if the action was prohibited. So the best point that you can focus on is that Aaron was acting not in the course of his employment. So if you just read through the problem again, I think it quite kind of overly says that it was just because he really wanted to race that car. And I think that would be your best point. And I would just pass on to Kelsey.
Is it me? Okay, just checking. Yes, okay, so we're back to postal rule, guys. Don't know if you missed it as much as I did, but hopefully that means my slides, you won't have so many questions to do with that. We are looking at a slightly different type of postal rule in this situation. Well, not a different type of postal rule, but different circumstances to the first moot problem. So I think it's beneficial to just go back to the facts and see exactly what we're talking about. So Hot Wheels garages placed an advert in a newspaper stating any repairs would be half price if a letter of acceptance was sent by Royal Mail by Tuesday, the 14th of February. And then Louis von Speed wanted to have repairs done to his 2017 supercar. So he passed a letter to a courier on the evening of the 14th of February. However, it did not arrive till the 16th of February. So there's a few things to pick out based on these facts. And the first one is what method of kind of posting was required. And obviously the advert did specify Royal Mail, and Louis von Speed sent it by courier. So there's something there that you need to argue about what was accepted in terms of how it would be posted. And secondly, the question is, did the letter have to arrive by the 14th of February to be accepted, or did it just have to be posted? So there are a few things that the seniors will have to cover when talking about the postal rule. Just going back. So we know that generally acceptance has to be communicated to the other party for there to be a binding contract. But the postal rule is the exception to this rule, and acceptance is binding on or at the time it was posted rather than the date that it was received. And this also applies even if the actual letter never reached the offerer, but we know it did, I think. And it was discussed in the case of Adams and Lindsell, which many of you did use in your internal competition. So well done for utilising that case. You'll need to do the same thing for the international competition. And we know that a method of acceptance can be specified. And in this instance, it was Royal Mail. So the court at first instance found for Mr. von Speed and allowed damages for the price of half of the repairs. So as the appellant, you will want to argue that the postal rule does not apply as he chose to post the letter by courier against the requirements, and possibly that he also posted it on the evening rather than letting it arrive at that time. So the case of Howell Securities Limited and Hughes is helpful to illustrate this point to the judge. You're essentially going to be arguing that the fact that a method of communication was specified means that anyone who wanted to benefit from this deal had to adhere to that. So there's just a little bit here about how to argue your grounds of appeal, because we saw some very good submissions from counsel during the internal competition, but it's just really important to make sure that you utilize the cases that you use and you spend enough time talking about the facts of the case to make sure that we understand how it applies to your submission. So firstly, you want to introduce what your ground of appeal is. We've seen the grounds of appeal earlier and they're in the moot problem, so you can just take them from there. You then want to support your ground with legal authorities. We recommend 2, and there aren't that many postal rule authorities, so it's likely that you're probably only going to want to use 2. And then you want to make sure you know whether the authority is binding on the court. A lot of the judicial intervention questions that we ask competitors is this case binding? And you will get such easy marks, I will tell you now, such easy marks if you can tell me whether it is and what case it was heard in. If you can, you're probably going to get 10 out of 10. And it's such an easy mark for people to pick up. So what you want to do when you're writing your submission is, if you're using a case, if you can see from the facts of the problem what case the court was heard in and whether it's persuasive or binding on the current case, because we are in the Court of Appeal now, then figure out whether it's binding or not and tell me when I ask you a question. If it doesn't say what the court is, then you're more than welcome to Google it. and figure out what case it is, or ask us beforehand. We'll answer any questions before the competition. So just let us know via email or WhatsApp. And then you want to say your quote to the judge and explain how it applies to the present case. So this could either be through facts, maybe the facts are very similar and that's what you want to rely on, or maybe it's the legal principles it brings up. And you want to say why it's relevant to your submission today, why it's relevant to your client's case, and the judge really wants to see how you interpret the facts and apply the legal principles to the current case. It's all about creating kind of interesting legal arguments and making sure that you have a solid understanding of what the moot problem is about and what the judgments and cases we're using are about. And we've just got some terminology here as well. Hopefully you'll all be familiar with many of these. A new one might be erred. I don't know if we've had that one before, but it essentially just means to make a mistake. So it might be in the moot problem, but it just means that it will say something like the judge at first instance erred in applying this case. So what that essentially means is that they were wrong to do that, or they were mistaken to do that. And you're welcome to use that in your submission, or just say that the judge was wrong to apply that case. Distinguish is also an important one. It's all about taking a binding case, looking at the facts or the legal principles of that case, and telling the judge that although the case is binding, it's so far removed from the facts of the current case that we shouldn't apply it, that it's going to not make sense if we were to apply it. And the court is able to make a different decision than what was found in that case. So that's a really good word to use when you're telling the judge that they shouldn't apply a specific case. And you would just ask the court to distinguish that case from their decision today. Liability we spoke about, which just means to be responsible or answerable in law. And vicarious liability is a strict method of liability on employers for the wrongdoings of their employees. Strict liability just means that you don't need to prove kind of something for liability to arise. Kind of doesn't make any sense because you still need to prove things for vicarious liability. But if the three elements that Rihanna spoke about earlier are present, liability is implied. That's essentially the way it works. So it's really important to make sure that those three elements are there, or argue that those three elements aren't there for the role of the appellant for the liability to not be imposed. And lastly, a frolic of one's own. If you can believe it, this is actually a legal test that we use. And I know it sounds a bit silly, but it essentially just means to be not doing an action which is not connected to the work of your employer, and to be doing it essentially just because you want to and not because it's anything to do with your role. And lastly, there's just some recommended reading, but I'm aware that not all the schools have access to these textbooks. And like I've said in previous lectures, it's not vital for you to actually do this reading. And everything we've said in the lecture slides is detailed enough for you to be able to succeed within the competition without it. And if you have any questions about the postal rule or vicarious liability and want to know a little bit more about it, you can just ask us and we'd happily provide another summary or speak about it in the workshops. So unless anyone has any questions, I think that brings us to the end of today's lectures.
Thanks very much indeed, Kelsey. I can't see any questions coming in, but they may come in. And so I am just going to run over the format of the international competition another time for you, just to make sure that it's completely clear. So this week we've had our first sort of seminar on the international moot problem, and that has been today's seminar as looking at constructing your argument as counsel for the appellant. Next week we will have the second half of that. So next week on Wednesday, at the same time, we'll be giving a seminar on constructing your argument as counsel for the respondent. Now, next week also, we are offering the option of a workshop. So schools can take us up on that if they would like to. And I will be emailing you all hopefully this afternoon, just to remind you, please, to send us as many available dates and times over the next week that you're available for that workshop. And please do try and put your time in UK time. It's very easy for me to get mixed up because we have schools joining us from a number of different countries. And so if you can put it in UK time, then it's much easier for me to see whether or not we have space and availability of tutors. I will also be at the same time sending on details of next week's seminar. And I will also be asking you for as many dates and times that you have available for the international competition. And I think it was Hannah that mentioned the dates of that competition, which will be from the 11th of March until I think it's I can't remember. I think it's the weeks beginning the 11th and the 18th of March. So it runs up, it's those 2 weeks. Remember that every school will be mooting twice. So you'll be mooting once as counsel for the appellant and once as counsel for the opponent, as a respondent. And so we need more than one time, please. And if you can give as many available times and dates as possible, then it is much more likely that we will be able to accommodate times that suit you best. We are hopeful that schools will be competing against different schools each time, but that will again depend on available dates and times for everybody. Are there any questions that have come up? I don't think any questions have come up in the meantime. Does anybody want to raise a hand and ask anything? Or do we think we have been pretty clear today? I'm not hearing anything or seeing anything. So without further ado, I think I am going to give you the rest of your afternoon or evening back, where it is that you're joining us. But many thanks indeed for joining us this week. I will be in touch with the recording of this session and more details about next week very shortly. But if you have any, we do have one question. So if you would like to unmute yourself, you're very welcome to ask the question.
Good afternoon, if it's still
Good
afternoon
afternoon.
over there.
It is.
Okay. So if I can just pull up the thing on my laptop, very sorry. I had a question concerning the frolic of their own thing. So in the facts of the case, it says that Aaron took out the car onto the main road to show his friend who lived nearby that he had Von Speed as a client. Mr. Von Speed had not consented to the car being driven on public roads. When Aaron returned to the garage and was reversing the car into the parking space, he negligently collided with a delivery truck and the car was severely damaged. So the fact that he went to the main road to show his friend anything didn't have anything to do with it. Like, he could have crashed the car on the main road, then okay, maybe you can say it's a frolic of his own. But then he was in the premises, if I'm correct, when he crashed the car.
Yeah, I mean,
so Kelsey, I'm just going to chip in here and say this is a really, really great question, but it might be best suited. I mean, Kelsey, by all means, let's have an answer. But I think this is exactly the kind of question that you can pose in a workshop when you will be in a kind of more one-to-one session with our students,
okay,
rather than in the seminar. But I think it's a great question. I'm not sure if there's a quick answer, Kelsey.
unfortunately, there's no quick answer, but that's
well,
exactly
let's not give out the answer just yet.
Okay.
Yeah, raise it in your workshop, but good thinking, and everyone else be on that line of thinking.
All right, thank you so much.
And no worries, thank you. And we do have a question from Nomi. So Nomi, if you want to unmute yourself and pose the question, then please do. I'm not sure whether, Nomi, I'm not sure whether you're able to unmute yourself. If not, then I'll give you another minute, certainly, to put the question either in the chat or in the Q&A, and we can verbalize that. Maybe the question has already been answered.
Hi, sorry,
Hi, Nomi.
it's been answered.
Oh, okay, that's fantastic. Many thanks.
Thank you.
Great. No worries. So I look forward to, so I will email you all as soon as I can, and I look forward to scheduling your workshops over the next week, over the coming week. But if there is anything else in the meantime, please feel free to let us know. We have the WhatsApp group. It's been very quiet, obviously, but please feel free to use that if you think the question is relevant to everybody. Or you can email us directly. So my email address is e.findlay@dundee.ac.uk, and I can certainly pose questions to our tutors, and your teachers all have that email address. So if you speak to them, if you don't have it just now, you can speak to them and get the email address from them. But I think from us all in Dundee, I'm going to wish you a very good afternoon, a very good evening. Enjoy the rest of your day, and we will look forward to seeing you next week. Goodbye.